Good afternoon, everybody. Thank you for joining us for today's webinar event. We're going to be covering temporary workers and the OSHA and labor and employment issues that are implicated by our nation's growing temporary workforce. My name is Eric Conn, the founding partner and chair of the National OSHA Workplace Safety Practice Group here at Conn, Maciel, Carey. I'm joined today by my associate, Lindsay Smith, and let us tell you briefly about ourselves, briefly about the subjects we're going to cover today, and then we'll jump right in. As I said, I co-founded the law firm Conn, Maciel, Carey, which is a relatively new boutique law firm focused on OSHA and labor and employment issues. We are based out of the Washington, D.C. area. We also have a West Coast office where we converge on the center of the country, providing labor employment and OSHA legal advice to our clients across all different industries. My practice focuses exclusively on safety and health law. I represent employers in inspections, investigations, and enforcement actions involving the litany of agencies that have jurisdiction over workplace safety and health, primarily OSHA and the state OSHA programs that implement regulations about workplace safety and health. I work with employers and expert witnesses, agencies, insurance companies, and everyone else who gets involved in investigations of catastrophic incidents and accidents at all sorts of different workplaces in all sorts of industries. I also handle the full range of OSHA litigation, from contesting citations to helping manage criminal investigations and criminal prosecutions under the OSHA Act, as well as working with attorneys that handle personal injury and wrongful death suits where there is a OSHA overlapping OSHA issue. I help consult with counsel in those areas as well. I also work proactively on safety and health issues, helping our clients develop safety and health programs or auditing safety and health programs that are in place, as well as providing safety and health training. I'll let my colleague Lindsay Smith introduce herself and her practice.
Hello, everyone. Good afternoon. My name is Lindsay Smith, and I'm an associate at Conn, Maciel, Carey. And I am actually an associate in both the OSHA practice as well as the labor and employment practice. As an associate at Conn, Maciel, Carey, I represent and advise employers on all aspects of the employment relationship, including reviewing policies and procedures as to wage and hour, assisting with claims of discrimination, and reviewing and revising handbooks. I also work with Eric in the OSHA practice, and we represent employers during inspections and investigations conducted by both federal and the state OSHA agencies, and assist in advising and counseling employers and responding to notices that they receive from both federal and state OSHA.
All right, so today we're going to be talking about temporary workers. We're sort of broken this down into two categories. One is the OSHA safety and health implications of temporary workers in your workplace, with a focus on OSHA's temporary worker initiative that was launched about a year and a half ago. We'll talk a little bit about what OSHA is focused on and what that means for employers who work with temporary workers. And then the second half of the presentation, we'll focus on the labor and employment issues implicated by the use of temporary workers and the temporary workforce. And Lindsay's going to cover some of the issues there involving misclassification of independent contractors and the application of the Affordable Care Act to this universe. So let's dig right in to the safety and health element of this. If you don't know, OSHA has launched a nationwide temporary worker initiative with enforcement and somewhat compliance assistance elements focused on the use of temporary workers in our workplaces. I'll say a little bit about why OSHA has launched this initiative and what it means for you. But first, let's talk a little bit about who are temporary workers. This is a pretty broad category of employees, generally speaking, not so much in the OSHA context, which I'll explain in a moment. But when you hear people talk about temporary workers, the Bureau of Labor Statistics uses several terms that generally encompass this work relationship. It might be independent contractors, contingent workers, on-call workers, temporary help agency workers, workers provided by contract firms. Generally speaking, it's individuals supplied to a host employer but paid by a staffing agency. That's what OSHA is talking about. When you hear me talk about the temporary worker initiative, that is the only relationship that OSHA is focused on at this time, and that is workers who are technically employed by a temporary staffing agency, but who are supplied by contract to a host employer. That's what a temporary worker is for purposes of OSHA's initiative, but as I said, there's lots of other relationships that employers might have with workers that also fall under this temporary worker category, and those are more relevant on the labor and employment side, the Affordable Care Act side that Lindsay will talk a little bit more about. But for our purposes, we're primarily focused on this individual supplied by temporary staffing agencies. That being said, regardless how some worker ends up in your workplace, there is a good chance that that worker is going to be treated by OSHA as your employee. Lindsay's going to talk a little bit about misclassification issues from a wage and hour standpoint and from other employment relationship issues. But from a safety and health standpoint, it's relevant to whether this person is your employee, because if they're your employee, you have all the responsibilities of an employer under the OSHA Act. And so OSHA and the OSHA Review Commission that hears cases on this will look at a series of factors to determine whether a host employer is actually the legal employer to the worker for purposes of safety and health responsibilities. And at a high level, the question that's asked is, does the host employer have the right to control the manner and means by which work is accomplished? That's the high-level question. And under that question, the OSHA Review Commission has identified a series of factors, none of which is necessary on its own, and none of which is dominant on its own, but it is a balancing test considering all of these factors will dictate to the Review Commission and to you doing this analysis on your own as to whether these workers are your employees. And generally those factors include, and they all sort of relate to this, does the host have the ability and the authority to control the means and manner of work? So the factors look at the skills required to do the job. If it's a very basic, low-level skill task, it's not necessarily something that I take that back. If it's a specialized skill, that's the idea. Is if it's a very specialized skill that only this outside contractor has, and that's why the host employer has brought them in, they're less likely to be considered an employee. And if it's a skill that is, generic and basic, or something that is clearly in line with the work that the host employer does on a day-to-day basis, the Review Commission is going to look at that and say the host employer in these circumstances is going to be controlling the means and the manner of the work, so it's more likely to be an employee. The location of the work, is it done at the host employer's location, makes it more likely they're your employee. The duration of the relationship, if it's a short duration, small project assignment, less likely to be treated as your own employee. But if you're using a temporary staffing agency but have workers coming through who are staying for months or years at a time, the Review Commission is going to look at that and weigh that in favor of saying that worker is really your employee for OSHA Act responsibilities. How is the worker paid? Where are the tools and instrumentalities coming from, the personal protective equipment coming from? If the host employer is providing that material, providing the tools to do the work, providing the PPE to do the work, the Review Commission is likely to find that they are your employees. And then you get into the discretion of the host employer, and those are the really important factors. Can the host employer assign additional projects beyond the scope of whatever the contract was that brought the worker into the workplace? Can the host employer, does the host employer have discretion on when and how long the worker performs tasks at the workplace? Can the host employer select a specific person from the contractor? If it's just a general contract to provide labor and the host has no say over who specifically does the work, then it's less likely that the host is going to be found to be in an employer relationship. Also looking at the ability to remove a specific contractor. If you have that authority to remove individual contractors, then it's more likely that you're going to be treated as the employer in those circumstances. And then, at the end of the day, are you controlling the means and manner of work? Are you telling them when, where, and how to perform the task? To the more extent you're doing that, the more likely you're going to be found as the employer for these temporary workers. There was a great example in 2004. The OSHA Review Commission looked at this circumstance where the employer was saying, wait a second, we've been cited for violations related to these temporary workers who are not our employees, who we don't have responsibility to provide certain training or to provide certain PPE or to implement various programs or to include those workers in the programs they implement at the workplace. OSHA disagreed, cited the host employer as the employer to these temporary workers, and the Review Commission went through and looked at those factors I just talked about. This was in the Frodert Memorial Lutheran Hospital case. It was obviously at a hospital system. There were temporary workers there performing various tasks, and the Review Commission looked at the various factors we talked about and said, these temporary workers are the hospital's employees, and therefore the hospital was responsible for all of these programs, all of this training, and all of this PPE, and upheld the citations. And the factors that they found to be important in evaluating that included that the PPE, the scrubs and gloves and respiratory protection were provided by the hospital to the employees. The tools to perform the job were provided by the hospital. The hospital had the ability to remove specific workers from the hospital and request specific workers be assigned. And at the baseline level, the hospital supervisors were supervising the work of these individuals on a day-to-day basis. And that immediate supervision, with all those other factors, weighed into the Review Commission saying, okay, even though these are temporary workers, even though they're supplied by a staffing agency, you, host employer, are responsible for the safety and health obligations that you have for any other regular employee of yours, and we're going to uphold these citations. Why is this important now? Maybe you've heard a lot of talk about temporary workers lately. I've been talking about it a lot lately. Maybe you've seen us write articles and blog posts about this. It became important, because it became important to OSHA. And I'm talking about it and thinking about it and advising my clients about it because this is a space where OSHA is paying a lot of attention. But why is OSHA paying so much attention to this now? The reason is the temporary workforce has grown substantially. During the economic recession, it was a way for employers to manage their overhead costs, to not make commitments for full-time staff, full-time employee hires, but to still have employees available, workers available to do their business. But more importantly, there is an expected surge in the use of temporary workers. And the reason for that is the rollout of the Affordable Care Act. And the Affordable Care Act includes some important elements that are being revisited by today's Congress, but in the current law talk about requiring employers to provide affordable health care coverage to their employees or to pay a fine or a penalty or a tax. I assume they'll call it a tax because that's what the Supreme Court said that it had to be. Pay a tax or provide this coverage if the employer has 50 or more workers who work at least 30 hours per week. So there's this evaluation that says if you have X number of employees who are essentially full-time employees, and there's some debate now about where that mark is going to be set for who a full-time employee is, but the idea being that if you have a certain number of full-time employees, then you fall into this category where you have this expense and burden to bear. So employers are expected by the federal government to look at themselves and say, where are we on that threshold? Are we just over the 50 workers? Are we just below the 50 workers? Are we hovering right around 50 workers? And to make some adjustments to their workforce, perhaps to keep themselves below that level, below that threshold number of full-time workers. And the way to do that without losing productivity is to go from full-time workers down to temporary and part-time workers. And, this is something that economists and the government and industry are expecting to happen. And one of the things we know from past experience, this is not just a wild guess. You look back at what happened in Massachusetts. Remember the great debates of Romney Care versus Obamacare. Massachusetts implemented its own version of the Affordable Care Act, several years ago. And when they did that, when the employer mandate kicked in, the use of temporary employment in Massachusetts increased 6 times faster than it did over the rest of the country. So this is a reasonable expectation that there will be a surge in the temporary workforce in the next couple of years. So that's why OSHA is paying a lot of attention to it. In addition to the fact that they're expecting lots of temporary workers, OSHA was also taking note of some other concerns that they have observed just from the increase in temporary workers over the course of the economic recession, some anecdotes that they observed and some statistics that they observed. And here's a little review why OSHA is concerned about an increase in temporary workers. One is that OSHA believes that employers use temporary workers to skirt their OSHA Act obligations. In other words, employers know that if they have a full-time employee, it is their employee, they're sending the paychecks, they have brought them in through their HR system, they are their employees, they have responsibility to provide training. They have responsibility to provide proper PPE. They have responsibility to record their injuries on their injury and illness logs. They have responsibilities to implement all of the required safety programs to protect those workers. OSHA thinks that employers are looking at it and saying, aha, if we bring in a contractor or bring in a temporary worker from a staffing agency, we don't have those obligations. The temporary staffing agency is the employer, so they have all those responsibilities. So OSHA thinks that this is a way that employers are deliberately trying to get around their OSHA Act obligations. OSHA also is concerned that employers use temporary workers to do the most hazardous or the most unpleasant jobs in the workplace as a way to keep their long-term and full-time employees, to keep morale high, to keep them from having to do the stinky job of jumping into a tank and cleaning out nasty chemicals. Let's bring in a temporary worker who's only going to be here for a few days, that my employees won't be unhappy having to do that job, and we just don't care about the happiness of somebody who's only going to be here for a week. This is OSHA's thinking that if there is going to be a surge in temporary workers, we can bet that those temporary workers are going to do the jobs that others don't want to do, and often those are the most dangerous jobs. OSHA's other concerns include the fact that this is a vulnerable workforce, that a temporary worker doesn't have as much power to speak up about unsafe conditions, or to defend himself, or to raise safety complaints, or to complain about a lack of training, because they are in a tenuous employment relationship. That a full-time employee has more of an ability to stand up to his employer and demand a safer workplace, to demand proper PPE, and worry less about their tenuous work relationship than a temporary worker does. So OSHA thinks that there is a need for OSHA to step in to be the voice of this temporary workforce, and that's why we're seeing this big focus on this by OSHA. The other thing that we've heard OSHA say, from their highest levels, Dr. Michaels giving speeches about temporary workers, is really, really focused on the training aspect of the employment relationship. That when you have full-time, long-term employees that you expect to be there for a long time, then you invest in proper training and thorough training in the hazards of your workplace, how to deal with those hazards, and how to do the job safely. But in OSHA's mind, if someone's only going to be there for a week, if they're only going to do one job or one task, then employers are just not going to give them either any training at all, or at least not the same level of training they provide to their full-time employees. And that's a big risk, especially if these workers are coming in to do more hazardous jobs. They're doing more hazardous jobs and getting less training. that's a recipe for dangerous situations and lots of incidents and accidents. So that is another reason why OSHA is extremely focused on temporary workers right now. And then OSHA has pointed out a series of data and anecdotes about very serious injuries and fatalities involving temporary workers, often on day one or theoretical day one in the first few days on the job, which OSHA has linked to inadequate training in the hazards present in the workplace and in the tasks that they are engaged in. So those are all the reasons why OSHA is very focused on temporary workers today. And that is why they launched what OSHA characterized as their Temporary Worker Initiative. An initiative is a little bit different. You've probably, if you've heard me give presentations in the past, you've probably heard us talk about various national emphasis programs and local regional emphasis programs where there's a directive that describes workplaces that are subject to inspections about certain types of hazards. This is slightly different. It's an initiative, not an emphasis program. And what I think that means is that this is an initiative for OSHA to gather lots of information about how temporary workers are used, where they're used, what types of jobs they're doing, which industries they're used most prevalently, and then subsequently, after they've gathered and analyzed that information, this initiative will transfer into an emphasis program. Once they can put some definition around it and put together a directive that makes sense, that's where I think this is headed next. But what do we have now? We have this Temporary Worker Initiative, which was designed by OSHA to address the safety and health of temporary workers. And again, the definition that OSHA is using for this initiative is just those temporary workers that are supplied to host employers and paid by staffing agencies. Goals of the initiative are to protect temporary workers from workplace hazards. It's to ensure that staffing agencies and host employers understand their safety obligations. Remember that OSHA is concerned that host employers are using temporary workers because host employers think if it's a temporary worker, I'm not responsible for them. Well, OSHA disagrees with that, and we'll talk a little bit about their joint responsibility here in a moment. But OSHA thinks that many host employers don't understand that they have safety and health obligations to temporary workers. So this initiative is intended to make sure that host employers do understand that. And likewise, the temporary staffing agencies also have responsibilities in this area, and they want to make sure that the temporary staffing agencies understand their obligations as well. And then the third bullet, and this is from the announcement about OSHA's Temporary Worker Initiative, the goals of the initiative. The third one is the one that raises a red flag to me. The third one is that OSHA is doing this to learn information regarding the hazards in the workplaces and the types of workplaces themselves that are utilizing temporary workers. And to me, that is a signal that we're gathering information and preparing to launch some sort of enforcement program. And frankly, the initiative is already an enforcement program because we'll talk about how they're implementing this data gathering exercise. First thing that happened when this Temporary Worker Initiative launched was that the Director of Enforcement for OSHA put out a directive to its compliance, safety, and health officers, to the area offices, saying, whenever you start an inspection, regardless of why it started, if it was a programmed inspection under OSHA's site-specific targeting program, or if you're there because of an accident, or if you're there because of an employee complaint, try to ascertain whether there are any temporary workers working at this workplace. And if there are, identify the tasks that they're involved in, identify the staffing agency where they came from, identify how prevalent the use of temporary workers are in this workplace. And if there are temporary workers present at all in this workplace, regardless of the reason you're there, regardless of what the purpose of this inspection was, if you discover that there are temporary workers present, you must expand the scope of the inspection to gather this information about temporary workers and to identify whether those temporary workers are exposed to hazards, whether they are adequately trained to deal with those, to understand and to address those hazards, And are they provided all of the necessary tools, equipment, personal protective equipment to deal with hazards in the workplace? So it's going to be a focus on training, it's going to be a focus on PPE, and it's going to be a focus on the safety and health programs that would protect those temporary workers from their jobs. So regardless why OSHA's there, they're going to be looking at these issues. And then as a major part of the directive is to document as much data as you can about the use of temporary workers there. And again, to me, this is all about OSHA gathering data so that they can look at it and say, okay, is it the healthcare industry where we're seeing the greatest use of temporary workers? Is it manufacturing? Is it the chemical industry? And what tasks are they most often doing when they are in these workplaces? And they're going to use that data to fashion a directive for an emphasis program that we will probably see within the next 2 years. Joint responsibility, and I know Lindsay's going to talk a little bit about this as well from the employment context, but joint responsibility is a huge mantra in this temporary worker initiative from OSHA. And the idea is, and this is David Michaels talking about the temporary worker initiative, saying that host employers need to treat temporary workers the same way that they treat their existing full-time employees. Temporary staffing agencies and host employers share control over employees, over these temporary workers. And therefore, the staffing agency and the host employer are jointly responsible for the temporary employees' safety and health. It is essential that both employers comply with all relevant OSHA requirements. And this sort of forecasted what we're seeing in the enforcement side of this temporary worker initiative, and that is that very often both employers, both the host and the staffing agency, are cited for the same issues or separately cited for different issues, but OSHA is opening inspections of both employers and very often holding both jointly responsible for safety and health violations. There is a big focus on training, and this is OSHA's view of who is responsible, or the shared responsibility between host employers and staffing agencies on the OSHA training side. OSHA says that it depends on who exercises day-to-day supervision. This is going back to our analysis at the beginning of the discussion about whether you are actually the employer to the temporary worker or to the contractor. If you are exercising day-to-day supervision, OSHA is going to hold you responsible for the training that is necessary to identify and protect against hazards in your workplace. There are various standards that require specific training requirements depending on the different industries that you're in, depending on the nature of your workplace, and depending on the job duties of the specific employee. And those training requirements will be divvied up depending on who is exercising supervision over the different elements of the training requirement. The host employer, OSHA says, is generally responsible for any workplace-specific, site-specific, or task-specific training. And the reason is that they are obviously in a better position to provide that training than the temporary staffing agency, who is on the outside, looking in. Hopefully they have some access, but generally the host employer knows the hazards better in their workplace, and therefore OSHA is holding host employers responsible for that site-specific or task-specific training. OSHA is holding staffing agencies responsible to provide at least some generalized basic safety and health training. And that is, training in, for example, take the hazard communication standard. OSHA would expect that the staffing agency is providing general hazard communication training, that is training about the hazardous chemicals that you might encounter in the workplace. The general training that OSHA is expecting from staffing agencies is, what is an SDS, a safety data sheet? How do you read it? What do the signs and pictograms and various hazard warnings and labels mean that you might encounter in the workplace? And then OSHA is expecting at a site-specific level that the host employer is providing more detailed training about the categories of hazardous chemicals that they are likely to encounter at their workplace. So there's that joint responsibility that you see that OSHA is expecting from hosts and staffing agencies. To the extent that a staffing agency is relying on a host employer's training, the expectation is that the staffing agency is doing something to ensure that that training is adequate, that they're paying attention to it, they're inquiring to make sure it's done, and perhaps even evaluating the quality of the training that's done. So again, even if you, and the same would be true of the host employer. If you're relying on training from the temporary staffing agency, OSHA is going to expect you as the host to evaluate whether that training is effective. If the employee comes onto your work site already trained to operate powered industrial trucks effectively, they're going to expect you to observe the operation of the powered industrial truck to make sure that whatever training the employee received from the staffing agency is really adequate for your workplace. Hazard communication, as I said, this is another big one, and it's, again, all of these standards that relate to or have a major training element are a big focus in this temporary worker initiative. And here, again, this is viewed by OSHA as a joint responsibility issue with high-level training, high-level awareness being provided by the staffing agency, site-specific awareness and training being provided by the host employer. Record keeping is another interesting one where we see a lot of questions and where we see OSHA focusing enforcement on the temporary worker initiative. And the issue there is, on whose log does an injury to a temporary worker belong? And OSHA has provided a fair amount of guidance on this, and we're seeing a fair amount of citations being issued on this. What it boils down to is an injury should not be recorded in more than one log. You don't have duplication. We're trying to get a good record of all of the injuries across industry, so you don't want duplication. It should only be on one log, and it should appear on the log of the employer who has day-to-day supervision of the worker who is injured. So this creates some complicating factors for host employers because you may provide day-to-day supervision of a temporary worker. The temporary worker gets injured. It's a recordable injury, but that temporary worker is then gone. He's no longer assigned to work in your location, and he's not your employee, so you don't have perfect access to information about how many days was the employee away, or would he have been away if he was still working at your location. What was the medical treatment provided? At what location was the medical treatment provided? Maybe you don't even know whether it was a recordable injury because you don't have access to the employee. What's required of host employers is that you make reasonable efforts to acquire the information to properly record injuries of those workers that you were providing day-to-day supervision. So this is just a little summary of these three major categories that OSHA is looking at. And in all three contexts, there is a sense of joint responsibility and overlapping responsibility of the two employers. So I'm going to talk real quickly about some best practices and then hand it over to Lindsay to talk about labor and employment issues. Best practices in this Venn diagram of responsibilities between host employers and staffing agencies. The best thing that you can do is to provide very clear communication between yourself as the host, between the staffing agency, and with the temporary worker himself. And the first place where you can start with this clear communication about who's responsible for what is in the contract itself. You should include very clear contract language that specifically sets forth the respective OSHA-related responsibilities between the host and the staffing agency. Understand that you cannot eliminate responsibility that is legally yours in all circumstances just by contract. So OSHA may look at it and say, hey, that's fine that you wrote in your contract that the staffing agency is responsible for training and hazard communication, but we're looking at the way you work with this employee, and this person is your employee, and we don't care what your contract says, we're going to hold you responsible. Now, that doesn't mean that OSHA's right, but it may mean that you're getting a citation for it. But regardless, it is a very, very important step to clearly document who is going to be responsible for what to make it less likely that something falls through the cracks. Because that's what OSHA is finding, or what they think they're finding, is that the host thinks the staff is taking care of the training, the staffing agency thinks the host is taking care of the training, and here it falls through the cracks, and they're going to hold both of you responsible. Have clear contract language it helps in two ways. One, it makes it less likely something falls through the cracks, and two, it gives you a good defense if you have pushed that responsibility onto the staffing agency if you do find yourself in a contest of OSHA citations. Second, I think it's very important that you conduct new hire or new project safety orientation training, or that you make sure that such training is provided. And here, this is, there's a balancing test between the more you oversee, the more you insert yourself into the work activities of the temporary worker, the more likely you're going to be found to be the employer to the temporary worker. But it is a good idea for you to make sure that everybody that comes into your workplace, visitor, regulator, employee, temporary employee, gets some orientation training into the hazards they may find at your workplace. And if you are trying to find a way to keep your hands off of the temporary worker so that you're not their employee, you're not found to be their employer, then you should make sure that the staffing agency is doing an effective orientation training and make sure that they understand what the hazards are that are present in your workplace so that they can do an effective orientation training. Third, maintain open communication, starting from the contract, through the training, through the day-to-day activities and communications between the staffing agency, the temporary worker, and the host, to make sure that you understand if there are safety complaints that are being made, so that you understand if employees or temporary workers are having trouble at your workplace. They don't understand what they're supposed to be doing. They don't understand the hazards. Open lines of communication will help you identify a problem before it becomes a problem. Identify hazards and develop protective measures. Regardless if you're talking about temporary workers, visitors, or your own employees, having an effective safety and health program, auditing to find non-compliance, and auditing to find hazards and correcting them is a great way to eliminate potential enforcement involving temporary workers. Assess whether temporary workers could be deemed to be your employees. Go back to those factors that we talked about early on and think, is OSHA going to consider this worker to be my employee? And if you reach the conclusion that it's a close call or that the answer is yes, then you need to implement your safety and health program the same way for those temporary workers that you do for your own employees, or change the way that you manage that relationship and push more back onto the staffing agency if you don't want to be held responsible for all of the safety and health requirements. But understand that OSHA is probably going to take a much broader view than you are, and they are very likely to find you jointly responsible regardless of how much you try to push those responsibilities back to the staffing agency. And then finally, review your policies, procedures, and training documents. Make sure they're effective. Make sure they're fully compliant. Understand that OSHA is likely to expand the scope of inspections at workplaces where temporary workers are used. So if they're there for a discrete issue, there's still a good chance they're going to be looking at your training records on other issues because of this temporary worker initiative. So you should get ahead of them, get out in front of OSHA, do your own audits of those programs, policies, and training requirements, and make sure that you're meeting those responsibilities. So I'm going to hand it over to Lindsay, and I will keep my eye on the chat box, and if there's any questions that come in, feel free to type those up, and we'll address those as they come in.
All right, so I'm going to take some time now to talk to you all about employment issues related to the temporary workforce. So Eric talked a little bit about this concept of joint responsibility, and it is also a significant issue in the employment context. So both states and federal agencies have been broadening their definition, their interpretation of the joint employer relationship. Eric spoke about OSHA's interpretation of how this relationship works. But another federal agency that has recently broadened the definition of a joint employer is the National Labor Relations Board. So in a case called CNN America, Inc., the National Labor Relations Board found that two entities could be considered joint employers when they share or co-determine those matters governing the essential terms and conditions of employment, and that the joint employer, the main company, would be found to be a joint employer if what that company does meaningfully affects the matters relating to the employment relationship, such as hiring, firing, discipline, supervision, and direction. So basically, this decision broadened their interpretation, or at least what the interpretation had been, of the joint employer relationship by making it so that both direct and indirect control of employees could establish the company as a joint employer. The NLRB actually also currently has 2 other cases before it dealing with the extent of the joint employer relationship, one of which, if the NLRB decides in favor of the union, would be a determination that both franchisors and franchisees have a joint employer relationship. And this would differ significantly from what the NLRB has held in the past, as it's found for the most part, under most circumstances, that franchisors are not in a joint employer relationship with franchisees. So going beyond federal agencies, some states have also broadened their interpretation of the joint employer relationship. Specifically, in California, as of January 1st, 2015, employers could be held liable for contractor violations of certain California labor code laws, regardless of control or direct participation in the violation themselves. So in the past, workers in California could only establish liability against the company by showing that an actual employment relationship existed between both the labor contractor that actually employed the temporary worker and the company to which the worker was assigned to perform those contracted services. And workers could often do that by showing that the company exercised significant and direct control over the workers' hours, wages, and working conditions. So under this new law, this showing would not be necessary for certain violations. The employer may now be deemed liable along with the third-party contractor who is actually hired and controlled the work of the temporary worker, no matter the extent of the actual control the company exerts over the temporary worker or contract worker. For example, the employer can now be liable for issues related to payment of wages, even if they have no control or participation in the payment of wages to a temporary worker hired by the contractor, which is often the case. The next issue I want to spend a little time discussing is temporary workers as independent contractors and misclassification of independent contractors. So the Fair Labor Standards Act, as most of you probably know, requires employers to provide certain rights to their employees, and employees specifically. For instance, the FLSA requires employers to pay employees at least the federal minimum wage and overtime for all hours worked in excess of 40 hours per week. Temporary workers may be classified as independent contractors, as independent contractors usually have a short-term, defined duration relationship with the employer. And this is significant because the FLSA does not apply to workers classified as independent contractors. Workers can, however, be misclassified as independent contractors, and this often occurs. And this could be a significant issue for the employer because, if the independent contractor becomes aware of misclassification, or if the Department of Labor becomes aware of misclassification, this could result in significant lost wages and overtime due to the employee, as well as other damages. So such a claim, particularly when more than one worker at an employer has been misclassified, has the potential to be quite costly for an employer. And actually, this misclassification of independent contractors is a really important issue right now because the Department of Labor has really emphasized the importance of investigating and enforcing correct classification of workers. And this is most prominently shown in the recent misclassification initiative that the Department of Labor and the IRS are both involved in. Under the initiative, the Department of Labor and the IRS are both involved in. Under the initiative, the Department of Labor and the IRS are both involved in. The Department of Labor and the IRS work together and share information to investigate and reduce the incidence of misclassification of employees as independent contractors. And not only is there a relationship between the Department of Labor and the IRS through this initiative, but currently 20 state agencies have also signed memorandums of understanding with the Department of Labor. And these memorandums of understanding are basically agreements that call for the state agencies to share information regarding independent contractor misclassification with the Department of Labor to establish a larger enforcement effort throughout the country. The most recent state to enter into one of these formal agreements is Alabama, and that just happened recently at the end of last year. The states that have made these agreements have also been allocated approximately $10.2 million in funding to improve their own misclassification detection and enforcement efforts. And this funding has been earmarked for various initiatives, including enhanced audit programs and employer education. And these audit programs can be similar to what you've probably seen, or what you may have seen through OSHA, and Eric kind of discussed this, where either the Department of Labor or the state agency could come in and check records, review job descriptions, employee responsibilities to see if they have been accurately classified as independent contractors. So for fiscal year 2015, a total of $14 million has been allocated for use in the misclassification initiative. $10 million, as I said, for the state agencies, and then another $4 million for enforcement efforts by the Department of Labor's Wage and Hour Division. The Department of Labor has also committed to conducting targeted wage and hour investigations in industries with the most substantial independent contractor abuses, and they will be doing this in conjunction with the Department of Treasury. So similar to what Eric discussed with OSHA and how they determine whether there is an employee relationship, the Wage and Hour Division also conducts a similar assessment if they are evaluating the classification of an employee versus an independent contractor. And there are multiple factors that are considered, as well as several different tests, actually, that have been promulgated by different federal agencies, the Supreme Court, to determine whether an employer-employee relationship exists. The goal of the Wage and Hour Division is to determine whether the worker is economically dependent on the employer, and this is basically the goal of all the tests that have been developed. And the factors within each of these tests are very similar, as it's going toward this same goal. The number one factor considered in these tests is the amount of control the supposed employer exercises over the individual. So more specifically, these factors that are displayed have been identified by the Department of Labor as those generally considered in determining whether an employment relationship exists under the Fair Labor Standards Act. And you'll notice that these are similar considerations to those that OSHA set out to determine the employment relationship. So the first factor, as I briefly explained in the prior slide, is the employer's nature and degree of control over the worker. This first factor addresses who sets the pay amount, work hours, who determines how the work will be performed, and whether the worker is free to work for other employers during this time period. An independent contractor must control the meaningful aspects of the work relationship. So generally, if an employer dictates how and when work should be performed, the worker is more likely to be classified as an employee. The second factor, extent work performed, is integral to the employer's business. If the work performed by a worker is integral to the employer's business, then the worker is more likely to be economically dependent on the employer. And as I explained, this supports more of an employee relationship. For example, if the employer is a large retailer, a worker who sells the retailer's product is more likely to be classified as an employee, whereas a worker hired to repaint the inside of a store or rewire the lights is more likely to be considered an independent contractor because her work, although very important to the employer, is not integral to the employer's actual business. So third, permanency of the employment relationship. A short, defined relationship suggests independent contractor status, while a permanent or indefinite employment relationship, there's no exact end to when the employee may finish their work for the employer, is more likely to suggest that it is an employee relationship. Next, workers' investment in equipment and facilities. An independent contractor should have a business investment in both in the work and the equipment used to perform the task, so that he or she shares in the risk of loss. Providing your own equipment to perform the work may support an independent contractor status, but that does not necessarily prove one way or the other that a worker is an independent contractor. If, for example, an employer reimburses a worker for the purchase of equipment necessary to complete a task, this tends to more support an employee status. The worker's opportunities for profit and loss. This factor focuses on whether the worker exercises managerial skills and or independent initiative, independent judgment on the job that would affect their own opportunity for profit and loss. If a worker can earn profit by working more efficiently or suffer a financial loss because they didn't work as efficiently and they took too much time, then that worker is more likely to be considered an independent contractor. And finally, level of skill, initiative, and independent judgment. If a worker's skills demonstrate that he or she exercises independent business judgment and the worker takes initiative to operate as an independent business in the competitive marketplace, then he or she is more likely to be classified as an independent contractor. Employers should not have to provide skills training to an independent contractor. They should already have that skill level to come into the workplace and perform that work in order for the worker to be able to perform the tasks assigned. All of these factors must be considered together to make a determination. One of them alone does not decide whether this individual is an independent contractor. As I said, the employer's nature and degree of control over the worker is very significant, but all of these factors have to be considered together to make a determination. And the Department of Labor actually, may disagree if they perform their own evaluation. They may disagree as to how these workers were classified. But going through this effort, considering these factors, it will at least support the fact that there was careful consideration of the classification and can be used to support the employer's position if any questions should arise as to classification. So finally, some recommendations for compliance. So as you are going through and determining the classification of employees and establishing that relationship, these are important things to consider and do to ensure compliance with the Fair Labor Standards Act. So the first there is memorialize the terms and conditions of an independent contractor relationship in a contract. So although courts have found an employment relationship, so the employee was wrongly classified as an independent contractor and should have been an employee, despite the parties' execution of an independent contractor agreement, independent contractor agreements should be signed by both the organization and the independent contractor to establish that there is an understanding there of what the relationship is. And thus the contract should include specific acknowledgement that the independent contractor is not an employee, and then lay out the terms of that employment relationship, or that independent contractor relationship, to be more accurate. Next, establish policies to limit direct control over the work of independent contractors. Management employees of the company should not provide direct control over the work of independent contractors. So you need to make sure that managers are trained and aware of the limitation of their control over independent contractors. So there is that distinction between the treatment of independent contractors versus the treatment and supervision of employees. Third, establish fixed limited duration employment relationship. Try to have the terms of the relationship be relatively limited, fixed duration with a well-defined endpoint. And when this is established, it should be evidenced in the independent contractor contract that is signed by both parties. Limit interaction between employees and independent contractors. Interaction between employees and independent contractors should be minimized to, again, support that distinction between the independent contractor and the employee. This could include separate trainings, separate communications to employees versus independent contractors, and exclusion of independent contractors from some social events like a Christmas party or something like that. And an independent contractor should not be provided an employee handbook or employee-specific policies. So if there are policies that independent contractors should be aware of at your workplace, if there's safety policies, for instance, then those should be distributed separately to independent contractors than what is specifically distributed to employees. Then finally, review policies to make sure they do not cover independent contractors. So the company should review vacation, sick, and other applicable paid leave policies to make sure that those policies are clear that they do not cover independent contractors. And something associated but slightly different from that, you should also make sure that benefit plans explicitly exclude independent contractors and temporary workers. Now we're going to discuss the applicability of the ACA a bit and the seasonal employee exemption. So the Affordable Care Act, as Eric briefly went over, requires applicable large employers to provide affordable health care coverage to full-time employees. Applicable large employer status is determined based on the size of the employer. And Eric discussed this a bit, that the standard is 50 or more full-time employees, or the combination of full-time and part-time employees equals 50 full-time equivalent employees at any point during the prior calendar year. You determine full-time equivalent status by adding up the hours worked by part-time employees during a particular month and comparing that with the full-time hours, the 30-hour requirement for full-time employees. So employee status is determined based on actual hours worked by the employee in a calendar year, so the either full-time versus part-time status or seasonal worker status. The consideration of part-time employees is really only for the determination of applicable large employer status. You do not need to provide coverage to part-time employees. It only is limited to full-time employees unless the part-time employee has been wrongly classified as part-time. But the actual coverage only has to be provided to full-time employees. Temporary workers are often hired for seasonal work, and there is an explicit exemption under the ACA for seasonal workers. You do not have to provide coverage, and it may impact the applicable large employer status. So the ACA's exemption for seasonal workers. An employer may be exempt from the ACA, meaning they are not classified as an applicable large employer, if its workforce exceeds 50 full-time employees for 120 days or fewer during the calendar year, and the employees in excess of 50 employed during that 120-day period are seasonal workers. And that four-month time frame does not have to be consecutive. So recently, seasonal employee has been defined under regulations promulgated pursuant to the ACA. And a seasonal employee is an employee in a position for which the customary annual employment is 6 months or less. The term customary refers to the fact that by the nature of this type of employment, a seasonal employee is typically in a position for 6 months or less and begins that employment during approximately the same part of each calendar year. This definition is somewhat flexible in that it allows a seasonal employee's employment to extend beyond the 6-month limitation in a particular year if unusual circumstances arise. For example, a particularly long, hot summer season may extend a hotel's need for lifeguards. In such circumstances, the lifeguard wouldn't automatically become a full-time employee simply because they go slightly beyond the 6-month time frame. So determining seasonal employee status is really important both for the exemption and determining whether this employee would actually be a full-time employee and needs coverage under the ACA. The seasonal employee exemption may be applicable to an employer, but it is important to carefully assess the employment characteristics of the workers hired as seasonal employees to ensure that they have been appropriately categorized because of the penalties under the ACA. They can be quite substantial if there is a violation of the Act. So to check this and make sure that they have been correctly classified, employers should use a look-back period to determine the classification of seasonal workers. And the look-back period is basically used to determine whether the employee averaged 30 or more hours per week during the effective period under consideration and determine the classification based on that evaluation. The look-back period consists of both a measurement period and an optional administrative period. And the measurement period can be anywhere from 3 to 12 months. That is left to the employer's discretion to determine exactly how long the look-back period should be. But the administrative period can be no more than 90 days. And the administrative period is really more of an opportunity after the consideration during the measurement period has been made of the hours worked during that period, just kind of getting everything together, making sure the classification is correct. And during the measurement period, the employer can evaluate the employee's work hours, determine the classification without incurring assessable payments for noncompliance with the ACA. It is important to note, though, that the measurement period and the administrative period together cannot last beyond the first calendar month beginning on or after the 1-year anniversary of the employee's start date. So once the look-back period is used and you determine whether the employee should be at full-time status or part-time status, then they have to be kept in that classification for what has been termed the stability period. So if you have classified them based on the measurement period as a full-time employee, then they have to maintain that status during the stability period. And the stability period is just basically the time during which an employee must retain his or her employment status as determined during the measurement period. That's all it is. And the stability period has to be equal to or greater than the length of the measurement period, but at a minimum it does have to be at least 6 months according to the ACA. So that means if you use a measurement period of 3 months, the stability period would still have to be at least 6 months. And generally, in summary, the same look-back period has to be applied to all employees. However, different periods may be used for certain categories of employees.
All right. Well, that's our review of the safety and health and labor employment issues implicated by the growing temporary workforce here in this country. If anybody has any questions, chime in on the chat function, or of course, you can always write to us or contact us. We're always interested in talking about these issues. I don't want to insult my colleague Lindsay, but if you couldn't tell from my discussion, I'm a huge OSHA nerd. I love talking about this stuff. I love hearing about it. I think she is too, but I'll let her characterize herself that way. But definitely feel free to reach out to us if you've got questions, comments, your own experiences with OSHA in this area to share. We always love to hear about it and love talking about it. And then also, this was webinar number 2 of a full series. I think there's between 10 to 12 different webinars we'll be doing over the course of 2015 on various OSHA subjects. Check out our website, connmaciel.com. There's various different locations on there where you can get to a summary of the webinar series. You can register for all of the remaining events or some of the remaining events. They should all be described there on our website. And as I said in the beginning, we will be sharing a copy of the handouts, a copy of the slides from today, and a link to the recording if you're interested in that. And I thank you very much for joining us, and certainly those folks that are buried up to their ears in snow. Thanks for joining us from your bathrobe at home. Everybody else that trudged in or has nice weather out on the West Coast or in the South, think about us as we're shoveling our way out the rest of this week. Thanks for joining us, and we'll talk to you real soon.